So you can see there, that's a coroner, one of the Victorian coroners at a scene recently. He's on your left, and the other person on the right in the blue jumpsuit is the forensic pathologist who's accompanied him to a scene of a death. And that's something that you wouldn't see a judicial officer normally doing. There's a similarity in that adversarial system in the sense that a judicial officer might be taken to a scene for a viewing, but it wouldn't be during the course of an investigation. It would be in the course of a courtroom hearing whereby all parties would accompany the judicial officer. So the coroner really is very active in terms of its investigation. But I also think that you have to be conscious that there are nuances between the adversarial system and the inquisitorial system. There are contrasts, but there are also shared features. So the coroner's inquiry isn't about resolving issues between parties, and it's not about ordering a legal remedy. Instead, it's an independent, objective investigation into a death to understand the circumstances of that death, the underlying issues and problems that contributed to the death, and to that end a coroner has the power to make a comment or recommendation. Now, the implication of the recommendation or the comment power means that in the inquisitorial process, there's often interested parties who are present at an inquest, and they have fundamentally and adversarially opposed objectives, in the sense that a coroner's comment or recommendation might potentially impact on someone's reputation or on their commercial viability or on their vocation. For example, a doctor may have been prescribing medication that was outside the relevant prescribing guidelines, and so that doctor might well be represented at an inquest as an interested party to argue through their legal representations as to why such a comment or an adverse finding shouldn't be made. And then there are inquisitorial features of the adversarial process. For example, parties aren't these days the sole arbiters of how litigation proceeds. Judicial officers do take an active role in managing litigation. Often parties are required to engage in compulsory mediation or arbitration before a matter comes to court, and there are also disclosure requirements to really identify the issues in a case. And if you look at a piece of legislation like the Family Violence Protection Act, now that's the legislation people use to make an application for a family violence protection order, there's a provision in that act that allows the magistrate hearing the case to inquire or to inform itself as it sees fit. So that's quite different to the usual understanding of the adversarial process. And in addition, in those hearings, the formal rules of evidence don't apply. In the Civil Procedure Act, in addition, there's judicial powers of case management, and judges and magistrates can impose sanctions on parties who aren't complying with timelines or disclosure orders. And there are features of the adversarial system that intrude into inquest hearings. As I said, people's interests who are affected have a legitimate interest and expectation in being heard. Sometimes it's very helpful to have someone to agitate a particular point of view in respect of a death, and whilst the rules of evidence might not apply, and say some evidence that's not of a particularly reliable nature might be admitted, in terms of the decision-making process of the coroner, they're going to require proof that is supported by evidence before any adverse finding is going to be made. So in 2008, the Coroners Court established Victoria's first inquisitorial court with a focus on preventing or reducing preventable deaths, and you'll see what there I've noted what the preamble provides for. I thought I'd actually take you through some figures that might be interesting to you. On average, about 35,000 people die in Victoria every year, and of that, about 10 or 12% of those deaths are reported to the coroner. These figures are slightly old, but you can see it sort of varies from year to year, probably about 12%. So the Coroners Court gets about 6,000 cases each year. And just in terms of a breakdown of some of those deaths, two things to note from this, and that is this is the death toll in Victoria of 366. If you look at the suicide rate, it is far in excess of the death of the road toll, as is the deaths from poisoning, which includes intentional and unintentional taking of pharmaceutical drugs. So that's higher than the road toll as well. I mentioned reportable deaths, and it's reportable deaths that give the coroner its jurisdiction to investigate. There's a jurisdictional nexus that's required for Victoria. Then the Act refers to types of deaths and types of people that make a death reportable. So it's Section 4 of the Coroners Act, if you're interested in having a look. If a death is unexpected, if it's unnatural or violent, or resulted directly or indirectly from an accident or an injury, then they're going to be reportable deaths. Or if it follows a medical procedure or is during a medical procedure where the death is causally related and not reasonably expected, that will be reportable. And in addition, the people whose deaths are reportable are people who are particularly vulnerable in our community. For example, people who are subject to the Mental Health Act, or people who are in prison, or in the control care or custody of police, or if their identity is unknown. And I've already referred to the findings that a coroner has to make as part of its investigation. Just very briefly, the historical origins of the coroner are such that, there are two certainties in life, death and taxes, and originally the coroner was in fact a tax collector for the Crown, because if there was an unexpected or violent death, there was the potential for being a revenue source for the Crown. And so the coroner was able to find communities for unexplained homicides, and in fact the coroner was the first investigator of crime prior to the establishment of police forces and prior to the establishment of the magistracy. And if the coroner found someone committed suicide, all of their property would be forfeited to the Crown. So that had significant and severe financial consequences for a deceased's next of kin. There are therapeutic aspects that the Coroner's Court has to comply when exercising a function under the Act, and that includes recognising the distress that families suffer and their need for support, and also respecting different cultural beliefs. During an inquest, that can take the form of asking the deceased's family how they would like their loved one to be referred to as, and also ensuring that they're not exposed unnecessarily to, say, distressing photos. Importantly, it's the coroner's role to investigate, but not to apportion blame. And so a coroner must not produce a finding containing a statement that a person might be guilty of an offence. If the coroner believes that an indictable offence may have been committed, the coroner must refer that case to the DPP for investigation and possible prosecution. And the coroner, as I referred to, has investigative powers, and they are can be of a coercive nature, and you can see that they are listed there in terms of entering premises, securing scenes, taking things, taking photos, requiring statements or documents. And as long as the coroner reasonably believes that it's necessary for their investigation, they're within power, and it's the police who do that for the coroner. In terms of the coroner's expertise, I referred to it being a specialist court. Coroners have to be over a range of different areas of expertise, including toxicology, effects of opioids, hospital procedures, police procedures, and there's a coroner's prevention unit that has been established to assist coroners with that process of understanding and providing expert assistance. And there's also a team of doctors and nurses at the Coroner's Court who will give advice in respect of cases where there's been a death, during a medical procedure or at a hospital that's been unexpected.